So I need to know what standard you're asking me to apply. Is it whether, as a rational matter, the separate parts could still function, or does it focus on the intent of the Congress? If you suppose you had Party A wants proposal number 1. Party B wants proposal number 2, completely unrelated. One is airline rates, the other is milk regulation. They decide them together. The procedural rules of these have to be voted on as one. They're both passed. Then one's declared unconstitutional. The other can operate completely independently. Now, we know the Congress would not have intended to pass one without the other. Is that the end of it? Or is there some different test? Because we don't want to go into legislative history. That's intrusive. So we ask whether or not as an objective, rational matter, one could function with that. I still don't know what the test is that we're supposed to apply. And this is the same question as Justice Scalia asked. Could you give me some help in that?
Sure. Justice Kennedy, the reality is I think this Court's opinions have at various times applied both strains of the analysis.
And which one and what test do you suggest that we follow if we want to clarify our jurisprudence?
I'm a big believer in objective tests, Justice Kennedy. I'd be perfectly happy with you to apply a more textually based, objective approach. I think there are certain justices that are more inclined to take more of a peek at legislative history, and I think if you look at the legislative history of this, it would only fortify the conclusion that you would reach from a very objective textual inquiry. But I'm happy to focus the Court on the objective textual inquiry.
I don't understand. And that objective test is what?
That is whether the statute can operate in the manner that Congress intended. And I mean,
no statute can do that, because once we chop off a piece of it, by definition, it's not the statute Congress passed. So it has to be something more than that.
Justice Sotomayor, every one of your cases, if you have a formulation for severability, if you interpret it woodenly, it becomes tautological. And Justice Blackmun addressed this in footnote 7 of the Brock opinion that we rely on, where he says, of course it's not just, it doesn't operate exactly in the manner because it doesn't have all the pieces. But you still make an inquiry as to whether, when Congress links two provisions together and one really won't work without the other.
What's wrong with the presumption that our law says, which is we presume that Congress would want to sever? Wouldn't that be the simplest, most objective test, going past what Justice Scalia says we have done, okay? Get rid of legislative intent altogether, which some of our colleagues in other contexts have promoted, and just say, unless Congress tells us directly it's not severable, we shouldn't sever. We should let them fix their problems. You still haven't answered me why in a democracy structured like ours, where each branch does different things, why we should involve the Court in making the legislative judgment.
Justice Sotomayor, let me try to answer the specific question and then answer the big picture question. The specific question is, you could do that. You could adopt a new rule now that basically says, look, we sever...
It's not a new rule. We presume. We've rebutted the presumption in some cases, but some would call that judicial action.
I think in fairness, though, Justice Sotomayor, to get to the point you're wanting to get to, you'd have to ratchet up that presumption a couple of ticks on the scale. But because the one
what's wrong with that?
One thing that's wrong with that, which is still at a smaller level, is that's inconsistent with virtually every statement in every one of your severability opinions, which all talk about congressional intent.
Well, it's not inconsistent with our practice, right, Mr. Clement? You have to go back decades and decades and decades, and I'm not sure even then you could find a piece of legislation that we refused to sever for this reason.
Well, I don't think that's right, Justice Kagan. I think there are more recent examples. A great example, I think, which sort of proves, and maybe is a segue to get to my broader point, is a case, it involves a state statute, not a federal statute, but I don't think anything turns on that, is Randall against Sorrell, where this Court struck down various provisions of the Vermont campaign finance law, but there were other contribution provisions that were not touched by the theory that the Court used to strike down the contribution limits. But this Court, at the end of the opinion, said, there's no way to think that the Vermont legislator would want these handful of provisions there on the contribution side, so we'll strike down the whole thing. And if I could make the broader point, I think the reason it makes sense in a democracy with separation of powers to, in some cases, sever the whole thing is because sometimes a half a loaf is worse. And a great example, if I dare say so, is Buckley. In Buckley, this court looked at a statute that tried to, in a coherent way, strike down limits on contributions and closely related expenditures. This court struck down the ban on expenditures, left the contribution ban in place, and for 4 decades, Congress has tried to fix what's left of the statute, largely unsuccessfully. Whereas it would have, I think, worked much better from a democratic and separation of powers standpoint if the court would have said, look, expenditures are, you can't limit expenditures under the Constitution. The contribution provision's joined at the hip. Give Congress a chance to actually fix the problem, not just fix the
Can I ask you one question, which is a practical question? I take as a given your answer to Justice Kennedy. You're saying, let's look at it objectively and say, would Congress have intended this, okay? This is the mandate and the community. This is Titles 1 and 2, the mandate, the community pre-existing condition, okay? Here's the rest of it. And when I look through the rest of it, I have all kinds of stuff in there. And I haven't read every word of that, I promise. All right, I mean, as you pointed out, there's biosimilarity, there's breastfeeding, there's promoting nurses and doctors to serve underserved areas, there's the Class Act, etc. What do you suggest we do? I mean, should we appoint a special master with an instruction? Should we go back to the district court? You haven't argued most of these. As I hear you now, you're pretty close to the SG. I mean, you'd like it all struck down, but if we're supposed to apply the objective test, I don't know if you differ very much. So what do you propose that we do other than spend a year reading all this and have you argue all?
Right. What I would propose is the following, Justice Breyer, is you follow the argument this far, and then you ask yourself whether what you have left is a hollowed-out shell or what you have.
I would say the Breastfeeding Act, getting doctors to serve underserved areas, the biosimilar thing in drug regulation, the Class Act, those have nothing to do with the stuff that we've been talking about yesterday and the day before. Okay? So if you tell me at that level, I'd say, sure, they have nothing to do with it. They could stand on their own. The Indian thing about helping the underserved Native Americans, all that stuff has nothing to do with it. Black lung disease, nothing to do with it. Okay? So that's, you know what you have there? A total off-the-cuff impression. So that's why I'm asking you, what should I do?
What you should do is let me say the following, which is follow me this far, which is the mandatory individual mandate is tied, as the government suggests, to guaranteed issue and community rating. Mm-hmm. But the individual mandate, guaranteed issue, and community rating together are the heart of this act. They're what make the exchanges work. The exchanges, in turn, are critical to the tax credits because the amount of the tax credit is keyed to the amount of the policy price on the exchange. The exchanges are also key to the employer mandate because the employer mandate becomes imposed on an employer if one of the employees gets insurance on the exchanges. But it doesn't stop there. Look at the Medicare provision for DISH hospitals, okay? These are hospitals that serve a disproportionate share of the needy. This isn't in Title I. It's in the other part that you had in your other hand. But it doesn't work without the mandate, community rating, and guaranteed issue.
Well, can I ask you this, Mr. Clement? What would your fallback position be if we don't accept the proposition that if the mandate is declared unconstitutional, the rest of the Act, every single provision has to fall? Other dispositions have been proposed. There's the Solicitor General's disposition, the recommended disposition, strike down the guaranteed issue and community rating provisions. One amicus says strike down all of Title I. Another one says strike down all of Title I and Title II. What would you suggest?
Well, I think what I would suggest, Justice Alito, I don't want to be unresponsive, is that you sort of follow the argument through and figure out what in the core of the Act falls. And then I guess my fallback would be if what's left is a hollowed-out shell, you could just leave that standing. If you want a sort of practical answer, I mean, I do think you could just, you could use Justice Breyer's off the cuff as a starting point and basically say, Title I and a handful of related provisions that are very closely related to that are really the heart of the Act. The bigger volume in his other hand, I mean, you could strike one and leave the other, but at a certain point, I'm sorry, Mr. Chief Justice.
Finish your certain point.
At a certain point, I just think that, the better answer might be to say, we've struck the heart of this Act. Let's just give Congress a clean slate. If it's so easy to have that other big volume get reenacted, they can do it in a couple of days. It won't be a big deal. If it's not, because it's very you can laugh at me if you want, but the point is, I'd rather suspect that it won't be easy. Because I rather suspect that if you actually dug into that, there'd be something that was quite controversial in there and couldn't be passed quickly.
But
and that's sort of the whole point.
The reality of the passage, I mean, this was a piece of legislation which had to be a concerted effort to gather enough votes so that it could be passed. And I suspect with a lot of these miscellaneous provisions that Justice Breyer was talking about, that was the price of a vote. Put in the Indian health care provision and I will vote for the other 2,700 pages. Put in the black lung provision and I'll go along with it. That's why many of these provisions, I think, were put in, not because they were unobjectionable. So presumably what Congress would have done is they wouldn't have been able to cobble together the votes to get it through.
Well, maybe that's right, Mr. Chief Justice, and I don't want to spend all my time on fighting over the periphery, because I do think there are some provisions that I think you would make as an exercise of your own judgment, the judgment that once you've gotten rid of the core provisions of this Act, that you would then decide to let the periphery fall with it. But if you want to keep the periphery, that's fine. What I think is important, though, as to the core provisions of the Act, which aren't just the mandate, community rating, and guaranteed issue, but include the exchanges, the tax credit, Medicare, and Medicaid. As to all of that, I think you do want to strike it all down to avoid a redux of Buckley. If I could reserve the remainder of my time.
Thank you, Mr. Clement. Mr. Kneedler.
Thank you, Mr. Chief Justice, and may it please the Court. There should be no occasion for the Court in this case to consider issues of severability because, as we argue, the minimum coverage provision is fully consistent with Article 1 of the Constitution. But if the Court were to conclude otherwise, it should reject petitioners' sweeping proposition that the entire Act must fall if this one provision is held unconstitutional. As an initial matter, we believe the Court should not even consider that question. The vast majority of the provisions of this Act do not even apply to the petitioners, but instead apply to millions of citizens and businesses who are not before the Court.
How does your proposal actually work? Your idea is that, well, they can take care of it themselves later. I mean, do you contemplate them bringing litigation and saying, I guess the insurers would be the most obvious ones. Without the mandate, the whole thing falls apart, and we're going to bear greater costs, and so the rest of the law should be struck down. And that's a whole other line of litigation?
Well, I think the continuing validity of any particular provision would arise in litigation that would otherwise arise under that provision by parties who are actually
What cause of action is it? I've never heard of a severability cause of action.
Well, in the first place, the point isn't that there has to be an affirmative cause of action to decide this. You could, for example, to use the Medicare reimbursement issues, one of the things this Act does is change Medicare reimbursement rates. Well, the place where someone adjudicates the validity of Medicare reimbursement rates is through the special statutory review procedure for that. And the same thing is true of the Anti-Injunction Act.
There are some provisions which nobody would have standing to challenge. If the provision is simply an expenditure of federal money, it doesn't hurt anybody except the taxpayer, but the taxpayer doesn't have standing. That just continues, even though it is so closely allied to what's been struck down that it ought to go as well. But nonetheless, that has to continue because there's nobody in the world that can challenge it. Can that possibly be the law?
I think that proves our point, Justice Scalia. This Court has repeatedly said that just because no one may have standing to challenge, and particularly like tax credits or taxes, which are challenged only after going through the Anti-Injunction Act, just because no one has standing doesn't mean someone must. But beyond that...
But those are provisions that have been legitimately enacted. The whole issue here is whether these related provisions have been legitimately enacted or whether they are so closely allied to one that has been held to be unconstitutional that they also have not been legitimately enacted. You can't compare that to cases dealing with a statute that nobody denies is constitutional.